Scalia Speaks, Chapter 24, The Freedom of Speech. Wesleyan University President Michael Roth warmly remembers the playful intellectual openness that Justice Scalia displayed during his visit to campus in March 2012. In addition to presenting the Hugo L. Black Lecture on Freedom of Expression, Scalia enjoyed the discussion and debate with undergraduates in a constitutional law course and spent much more time with them than we could have expected. I plan to discuss the originalist approach to constitutional interpretation in general, the application of that approach to the free speech provision of the First Amendment, and because this is, after all, the Hugo L. Black Lecture, to say a little bit about how an originalist approach differs from the views of Justice Black. Let me begin by telling you what originalism is. The Constitution, as you know, contains a number of broad provisions which are necessarily vague in their application: due process of law, equal protection of the laws, cruel and unusual punishments, the freedom of speech, to name a few. Originalism gives to those terms the meaning they were understood to have when the people adopted them. Is the death penalty cruel and unusual punishment? A hard question, perhaps, for the non-originalist. I have sat with 4 colleagues who thought it was. But for the originalist, the answer is easy. At the time the people ratified the Eighth Amendment, the cruel and unusual punishments clause, no one thought it forbade the death penalty. The death penalty was, at the time, and remained for some years later, the only penalty for a felony. Originalism is not a novel approach to textual interpretation. In fact, it remains the approach that virtually everyone uses for statutes. Nobody thinks that a statute's meaning changes from decade to decade. And originalism was, for the most of our history, the orthodox manner of interpreting the Constitution as well. Justice Story and Chief Justice Marshall would have been astounded at the notion that the Constitution changes to mean whatever each successive generation would like it to mean. It would not be much use to have a First Amendment, for example, if the freedom of speech included only what some future generations wanted it to include. That would guarantee nothing at all. To be sure, the Constitution has to be applied to new and emerging phenomena. The First Amendment, for example, had to be applied to radio in the 1920s and must be applied to the internet today. But under an originalist interpretation, its application to pre-existing phenomena does not change. Libelous face-to-face oral communication that was unprotected by the First Amendment at the time of the framing remains unprotected today. Moreover, those pre-existing applications are the data that determine the First Amendment's application to new phenomena. Thus, libel over the radio or on the internet is unprotected as well. Let me proceed now to apply originalist methodology to the speech guarantee of the First Amendment. I start where originalists always start, with the text. Congress shall make no law abridging the freedom of speech or of the press. A good example of how originalist and non-originalist interpretations differ can be seen by applying this text to laws providing causes of action for libel. There is no doubt that at the time it was adopted in 1791, no one thought that this provision invalidated laws against libel, which existed then and have continued to exist ever since. The issue is an easy one for originalists. Libel laws are constitutional. The famous case of New York Times versus Sullivan, 1964, much beloved by the press, is a classic example of non-originalist interpretation. That case held that suit would not lie for libel of a public figure, unless the libel was in bad faith. That is, with knowledge or reason to know that it was false. There is no doubt that libel of a public figure was unprotected by the First Amendment in 1791, and it remains unprotected speech, by the way, in England. But the Warren Court determined, as the framers had not, that allowing good faith libel of public figures would be good for democracy, and so the First Amendment was revised accordingly. Justice Black voted along with the majority in that case, though he would have gone even further to say that no libel, not even bad faith libel, was outside the scope of the freedom of speech. Here are a few excerpts from his opinion. I vote to reverse exclusively on the ground that the Times and the individual defendants had an absolute unconditional constitutional right to publish in the Times advertisement their criticisms of the Montgomery agencies and officials. State libel laws threaten the very existence of an American press virile enough to publish unpopular views on public affairs and bold enough to criticize the conduct of public officials. In my opinion, the federal Constitution has dealt with this deadly danger to the press in the only way possible without leaving the press open to destruction, by granting the press an absolute immunity for criticism of the way public officials do their public duty. How Justice Black arrived at this view is summed up in an interview he gave in 1962. I am for the First Amendment from the first word to the last. I believe it means what it says, and it says to me, government shall keep its hands off religion. Government shall not attempt to control the ideas a man has. Government shall not attempt to establish a religion of any kind. Government shall not abridge freedom of the press or speech. It shall let anybody talk in this country. As I said earlier, originalists are textualists. They begin with the text. So, you might expect me to agree with Justice Black. But the flaw in his reasoning is that the First Amendment does not say that government shall not abridge freedom of speech. It says that government shall not abridge the freedom of speech. That is, that freedom of speech, which was the understood right of Englishmen. Thus, there are several types of speech or categories of speech unprotected by the First Amendment because the framing generation never understood them to fall within the freedom of speech. Libel is one of them. Another is obscenity. Justice Black would not acknowledge that exception either. He wrote in one dissenting opinion, in my view, the First Amendment denies Congress the power to act as censor and determine what books our citizens may read and what pictures they may watch. But for the foreseeable future, this court must sit as a board of supreme censors, sifting through books and magazines and watching movies because some official fears they deal too explicitly with sex. I can imagine no more distasteful, useless, and time-consuming task for the members of this court than perusing this material to determine whether it has redeeming social value. This absurd spectacle could be avoided if we would adhere to the literal command of the First Amendment that Congress shall make no law abridging the freedom of speech or of the press. Now, I agree with Justice Black that it is distasteful, useless, and time-consuming for the court to sort through obscene materials, deciding what should and should not be allowed. But it is non-originalist jurisprudence that has made this a difficult chore by adding to the requirement that the material appeal to a prurient interest in sex, the requirements that it do so as a whole, that it portray sexual conduct in a patently offensive way, and that, taken as a whole, it not have serious literary, artistic, political, or scientific value. In any case, it is only Justice Black's literal reading of the First Amendment, which, as I have said, is not really very literal, that enables him to avoid the difficulty. One outspoken critic of originalism has called Justice Black by far the most successful originalist of the last century. Both the adjective and the noun are wrong. As for successful, only Justice William O. Douglas ever joined Justice Black in his absolutist views of the First Amendment, and no one on the current court has taken up their banner. And as for originalist, as we have seen with respect to the First Amendment, Justice Black did not take an originalist approach. His opinion in New York Times versus Sullivan, for example, spent a great deal of time explaining why libel laws were a bad idea, and then, for support in the original understanding, offered up a footnote with a single citation, telling the reader to see, for example, an 1803 commentary from a law professor that did not even support his claims. There are other examples of speech that is unprotected by the First Amendment because the freedom of speech was not understood to cover it. Incitement to violence and fighting words, for example. Other speech, such as criminal conspiracy and solicitation or fraud, has not yet come before my court in a First Amendment case, but since these forms of speech have long been criminalized without serious First Amendment challenge, I doubt we would find that the First Amendment was understood to protect them. I have no idea how Justice Black would have handled them. Would he really say that laws prohibiting false advertising are unconstitutional? Under an originalist approach, not only is speech unprotected at the founding unprotected today, but speech protected at the founding remains protected today. Exemplifying that point is a recent Supreme Court case, Brown versus Entertainment Merchants Association, which involved a California law restricting the sale or rental of violent video games to minors. First, the court, in an opinion I wrote, reaffirmed the principle I mentioned earlier, that the basic principles of freedom of speech do not vary with a new and different communication medium. Next, it noted that the First Amendment excludes from its protection certain limited categories of historically unprotected speech, such as obscenity, incitement, and fighting words. But speech about violence was not among those historically unprotected categories. The California legislature was not free to create its own new category of unprotected speech, speech about violence, by weighing the value of such speech against its social costs. That balance was already struck by the founding generation, and we are not free to reweigh it on a continual basis. The California statute was invalid. Thus far, I have spoken mostly about the original meaning of the freedom of speech, but even in free speech cases, that is not the only part of the First Amendment that the originalist approach helps elucidate. In some of those cases, it may be fairly easy to determine that the speech at issue is protected by the First Amendment, but much harder to tell whether the government has abridged that freedom. In National Endowment for the Arts versus Finley, a majority of my court made things very difficult for itself in upholding as constitutional a federal statute that allowed government subsidies only for art that was determined to be decent and in line with American values. The court engaged in what I consider extreme mental and linguistic gymnastics to conclude that the law did not discriminate against artists based on the viewpoint expressed in their art. For me, that vote was much easier. Of course, the law discriminated based on the views expressed by the artist. And if the National Endowment for the Arts had been deciding whether to fine or punish the artists, the law would certainly have been unconstitutional. But instead, the NEA was deciding only whether the artists should receive government subsidies for their work. When the Bill of Rights was passed, as now, to abridge meant to contract, to diminish, to deprive of. Simply put, when the government decides not to pay you for your speech, it is not abridging the freedom of speech within the meaning of the First Amendment. Now that you have seen examples of the application of originalist methodology, let me address some of the principal criticisms lodged against it, not just in the First Amendment area, but generally. Some claim that it is just camouflage for the imposition of conservative views. That is patently false. The best proof I can give is another free speech case, Texas versus Johnson, in 1989. There, the Supreme Court held that it was a violation of the First Amendment to make unlawful the burning of an American flag. I consider that action a form of speech, which shows, by the way, I am not a strict constructionist. Texts should be construed neither strictly nor sloppily, but reasonably. And if you think the First Amendment covers only speech and press in the literal sense, which is what Justice Black said he believed, you must believe that Congress can censor handwritten mail. Of course, speech and press are stand-ins for the expression of ideas, and that expression can be made through symbols and symbolic acts as well as through words. Semaphore and Morse code are covered, and so is the burning of a flag, a classic expression of disapproval or contempt for the government that it represents. The court held in Johnson that it was unconstitutional to ban the burning of a flag. It was a 5-4 decision, and I made the 5th vote. You should be in no doubt that, patriotic conservative that I am, I detest the burning of the nation's flag, and if I were king, I would make it a crime. But as I understand the First Amendment, it guarantees the right to express contempt for the government, the Congress, the Supreme Court, even the nation and the nation's flag. And I could give you many other examples of opinions that I have joined and written that reach decidedly unconservative results. In the criminal law field in particular, I have insisted upon protections for the accused that a law and order conservative ought not to like. Far from facilitating conservative opinions, originalism prevents judges, conservatives, and liberals alike from judging according to their desires. Another criticism of originalism, perhaps the most common one, is that it petrifies the law. Thus, the approach set up in opposition to originalism is sometimes called the approach of the living constitution, a constitution that evolves as the needs of society require. Seems very attractive, but if you think that the proponents of a living constitution are trying to bring you flexibility and the power to change, you should think again. A constitution is designed to provide not flexibility, but rigidity. And that is precisely what the proponents of a living constitution use it for. The originalists' constitution permits expansive change when the people desire it. Do you want the death penalty? Elect those who will impose it. Do you abhor the death penalty? Elect those who will abolish it. And you could change your mind. If you find that the murder rate goes up after the abolition of the death penalty, elect those who will reinstitute it. If, however, the living constitutionalists have their way and declare the death penalty unconstitutional, the people's power to choose is eliminated. No death penalty, period. That is what has happened, of course, with abortion. The Constitution says nothing about the subject. It neither forbids, as the pro-choice people claim, nor requires, as the pro-life people claim, restrictions upon it. For 2 centuries, laws in every state prohibited it, but now, under a living constitution theory, it cannot be prohibited. No use trying to persuade your fellow citizens one way or other about the subject. It has been taken off the democratic stage. And that is, of course, precisely what those who argued for Roe v. Wade desired to achieve. So don't love the living constitution because it will bring you flexibility and choice. It will bring you rigidity, which is precisely what it is designed for. The third criticism of originalism is that judges are incompetent historians. History, after all, is a science unto itself, and a science different from the science of law. Judges are trained as lawyers. What possible reason is there to believe that they can function effectively as historians? To begin with, I deny the premise that law has nothing to do with historical inquiry. Utterly central to the law is the meaning of words, and the meaning of a word often changes over time, as any reputable dictionary will show by its use of a parenthetical description such as OBS, obsolete. Thus, the assertion that inquiry into the past has nothing to do with the laws begs the question. Historical inquiry has nothing to do with law only if original meaning is irrelevant, only if the law means not what it meant when adopted, but what it ought to mean today. To tell the truth, even the most thoroughgoing non-originalist will often have to resort to historical inquiry. Otherwise, what possible meaning could he assign to such phrases in the Constitution as the privilege of the writ of habeas corpus, bill of attainder, letters of marque and reprisal, cases of admiralty and maritime jurisdiction, corruption of blood? It would not be accurate, however, to suggest that the only historical inquiry demanded of originalists is a sort of lexicographer's investigation into the verbal usage of an earlier time. That is part of the enterprise, to be sure. Let me use a fairly recent Second Amendment case, District of Columbia versus Heller, as an example. There, the petitioners contended that the term bear arms in the Second Amendment had an exclusively military connotation. It was necessary and even easy enough for the court's originalist opinion to show that this was not so, by citing many examples of usage prior to and contemporaneous with adoption of the Second Amendment. This is, as I say, almost lexicographer's work. But other historical inquiry was demanded as well. One of the significant aspects of the Second Amendment was that it did not purport to confer a right to keep and bear arms. It did not say that the people shall have the right to keep and bear arms, or even that the government shall not prevent the people from keeping and bearing arms, but rather that the right of the people to keep and bear arms, as though it were a pre-existing right, shall not be infringed. The First Amendment is not so different in prescribing that Congress shall make no law abridging the pre-existing freedom of speech. In Heller, this reference to a pre-existing right engenders historical inquiry, which showed that, indeed, the right to have arms for personal use, including self-defense, was regarded at the time of the framing as one of the fundamental rights of Englishmen, described as such by Blackstone and found in the explicit guarantee of the English Bill of Rights of 1689. Once that historical pedigree was understood, it was difficult to regard the guarantee of the Second Amendment as no more than a guarantee of the right to join a militia. Moreover, the prologue of the Second Amendment, a well-regulated militia being necessary for the defense of a free state, could not be logically connected with a personal right to keep and bear arms without the historical knowledge, possessed by the framing generation, that the Stuart kings had destroyed the people's militia, not by disbanding it, but by disarming those of its members whom they disfavored. Here, the opinion was surely dealing with history in a broader sense than mere lexicography. I must concede, therefore, that in some cases, historical inquiry into the original meaning may be difficult. An example from the free speech field is the 1995 case of McIntyre versus Ohio Elections Commission, which involved a First Amendment challenge to state requirements that all election campaign literature must identify the person or organization promulgating it, printed by Citizens for Schwartz. All the states had such requirements and had had them for over a century. The plaintiff in the suit claimed that they were unconstitutional since she had a right to anonymous political speech. It was quite difficult to determine what the people who ratified the First Amendment would have thought of such a claim, since the election process was so radically different before we adopted toward the end of the 19th century the Australian ballot, that is, the secret ballot. While I cannot determine what the framers thought, I am disinclined to think that for over a century, all the states, with no registered protest, misunderstood the First Amendment. And so I rejected the challenge. Justice Thomas, another originalist, accepted it and wrote the opinion for the court holding such identification requirements unconstitutional. He relied for that conclusion upon the fact that the Federalist Papers, the most famous political tracts of the time, were published anonymously under the name of Publius. Pseudonymous political speech was common at the time, and Justice Thomas concluded must have been valued by the framing generation. A not unreasonable conclusion, as I also think was mine. For those keeping score, Justice Black shared Justice Thomas's view that the First Amendment protects a right to anonymous speech, but we know by now that Justice Black thought all speech was protected by the First Amendment. So the originalist methodology does not always yield a clear and easy answer, but the question before the House is not whether originalism is perfect. I will stipulate that it is not. The question is whether it is better than anything else. My burden is not to show that originalism is perfect, but merely to show that it beats the other available alternatives. And that is not difficult. In the vast majority of cases, and especially the most controversial ones, the historical inquiry will be easy. Is libel of public figures prohibited by the First Amendment? Is the death penalty prohibited? Are laws against abortion, homosexual sodomy, and assisted suicide prohibited? It is a piece of cake to determine that no one in the founding generation thought so, and for the more difficult questions, judges have the assistance of a growing number of legal historians on law faculties and history faculties to provide expert assistance on historical questions, just as engineers provide expert assistance on patent questions and economists on antitrust questions. By contrast, how are the living constitutionalists going to arrive at their decisions? To tell the truth, I don't know, and neither do they. How are they to decide what are the evolving standards of decency that mark the progress of a maturing society? The criterion of constitutional evolution that our Eighth Amendment opinions set forth. What would an elite group of the country's best lawyers, isolated in a marble palace, know about that? Earlier Supreme Court cases looked to the consensus of state laws. That is a dubious criterion of evolved standards to begin with. If it were true, which it is not, that a majority of the states have abolished the death penalty, that would not show that the people of those states consider that penalty unconstitutional rather than just a bad idea, any more than the fact that a majority of states forbid the union shop would show that they consider the union shop unconstitutional. In any case, the Supreme Court has abandoned this approach and has explicitly said that what the living Constitution prescribes does not depend on any consensus of state laws, but on the judgment of the justices. Do you think that judges, that is to say lawyers, are better at the science of what ought to be than at the science of history? The reality is that originalism is the only game in town, the only real verifiable criterion that can prevent judges from making the Constitution say whatever they think it should say. Show Scalia the original meaning, and he is prevented from imposing his nasty conservative views upon the people. He is handcuffed. And if he tries to dissemble, he will be caught out. The source material is accessible to all. Convenient omissions of inconvenient evidence can easily be identified. Suspect conclusions can be effectively challenged. But if original meaning is not the criterion, what other criterion can there be that prevents judges from imposing their ideological preferences on society? Now think about it. There is none. The living constitutionalist is a happy fella because it turns out that the Constitution always means precisely what he thinks it ought to mean. That is indeed much of the attraction of the living Constitution. And it is an attraction not just to judges, but to the people at large. How wonderful to think that whatever you care passionately about, from abortion to the death penalty, is resolved precisely the way you think it should be by the Constitution. Never mind whether the people ever voted to put that in the Constitution and thus to remove it from the realm of democratic choice. Only originalists care about that. It is there if it ought to be there. I urge you not to yield to that seductive and extremely undemocratic falsehood. The American Republic is a democracy, and the background rule of democracy is that majority rules. We discuss matters, try to persuade one another, and then put it to vote, directly or through our representatives. And the majority rules. But in a liberal democracy, which we are, the majority does not always rule. It does not rule with regard to the freedom of speech or freedom of religion or the right to bear arms or the right to trial by jury and so forth. The provisions of the Bill of Rights. But who adopted those limitations on democracy? The people themselves, not some committee of judges. And it is only the people themselves who can add to or subtract from those limitations through the amendment provision of the Constitution. If you believe in democracy, you are an originalist, because it is only the limitations that the people voted for, which means the limitations that the people understood they were imposing, that can frustrate the will of the people.